Hello, my name is Chris Chapman, and I'm here before you. You see a subpoena to testify before a grand jury. Now, I was subpoenaed back in December on or about the 15th of 2007 for IRS, and they wanted to do exemplars. You see, the subpoena says here, excuse me. The subpoena says here, pursuant to the criminal investigation, which they were investigating me, handwriting exemplars. However, if I was willing to meet with the Special Agent Davis Solar, I could appear before him instead of going to the grand jury. However, the subpoena says I am commanded to appear and testify before the grand jury, and that's what I wanted to do. And when I expressed my excitement of wanting to testify, then they redid it and wanting to do a handwriting, voice, fingerprint, and photograph and exemplars. And again, saying that, hey, I can meet with him before the grand jury, before I get to the grand jury, and everything would be done. But I was, like I said, I wanted to get before the grand jury. I needed to. Now, the history of this is I haven't filed since 1993. That's a fact. I haven't filed because I learned since 1988, going on for 5 years, I learned that there is no law that it requires me to pay. So I have put them on notice. I can't find any evidence that I'm a taxpayer, and they never responded. Then, through the course of the years, and a lot of harassment and a lot of battles with the IRS on a local level, as well as many letters going back and forth, they finally came to the point where they wanted to subpoena me before a grand jury. Now, here you will find the subpoena that I'm to appear on January 3rd of 2007, that this was issued to appear on January 10th, which I did. Now, when I went to the grand jury, I stood on mainly, there's many options. You can argue you're not a taxpayer, you can argue this, and you can argue that. But in my mind, I wanted to know by what authority do they have to even speak to me. We'll get to the taxpayer after you get to, after you pass the first question, then we'll see what the next question is. But if you can't pass the first question, there's no need to go any further. So I've always asked them, by what delegation of authority do you speak to me? What delegation? Is it by Congress? Is it by, smoke and mirrors? How is it that you can come into Florida when Congress has written no laws that requires you or has given the secretary any authority to come into Florida? Now, here's the following. Under Title IV, Section 72, all offices attached to the seat of the government shall be exercised in the District of Columbia and not elsewhere, except as otherwise expressly provided by law. Now, Black's Law Dictionary explains the definition of express. In an express manner, in a direct, unmistakable terms, explicitly, definitely, directly, okay, and that's to a court case that supports that. Then the official power cannot extend beyond the terms and necessary implications of grant. If broader powers be desirable, they must be conferred by Congress. Nobody else can write it. The president can't do it. The secretary can't do it. Their mothers can't do it. Now, Congress does indeed follow mandates of Title IV, Section 72, even in the territories or insular possessions over which it has executive legislative jurisdiction. For example, the defendant cites the following, which shows conclusively that the Congress will do when it intends to expressly authorize the Secretary to administer and enforce Internal Revenue laws outside the District of Columbia and not elsewhere, and within the several states. 48 U.S.C. Section 1397 gives express intent that the Virgin Islands will have to deal with the income tax laws as you see here. And Title 48, 1421I, income tax laws in force in the United States of America, and those which may hereafter be enacted shall be held to be likewise enforced in Guam. Then the following, in 1801 of U.S.C. 48, you'll see the Commonwealth of the Northern Mariana Islands. So they're very specific, expressly stated. And in Section 601, it says the income tax laws in force in the United States will come into force in the Northern Mariana Islands as a local territorial income tax on the first day of January. And, the laws are forced in Guam. So it shows that, when it comes to the 50 states, that Congress did not run out of ink. And it's been well-established principle of law that all federal legislation applies only within the territorial jurisdiction of the United States unless a contrary intent appears. And you can find that in Foley Brothers versus Falero. However you say it. Anyhow, the laws of Congress in respect to those matters do not extend into the territorial limits of the states, but have force only in the District of Columbia and other places that are within the exclusive jurisdiction of the national government. So when you bring up Title IV, Section 72, the judges will normally, or the DOJ, and the judges, because the DOJ didn't argue anything. In my case, the judge was basically did all the arguing. The DOJ just sat there. The grand jury should not be deceived. Now, I gave this to the grand jury. This is what I call a grand jury handout. I gave this to every grand jury, and I wanted them to understand the basics of Title IV, Section 72. And I stated that the grand jury should not be deceived by the smoke and mirror tactics of the U.S. attorney. And because the U.S. attorney will always bring up, or most of the time that I've found, brings up Hughes versus the United States. The Hughes ruling claims that Title IV, Section 72 does not foreclose the authority of the IRS outside the District of Columbia, which is kind of yes and kind of no. The only reason given by the Hughes case is that the president is authorized in Title 26 U.S.C. Section 7621 to establish internal revenue districts outside of Washington, D.C. The rebuttal of the argument will be as follows. It should be clear to the grand jury that the Hughes case to state that the president is authorized to establish internal revenue districts outside of Washington, D.C. is not the same thing as saying that the president can establish said districts within the several 50 Union states, especially in light of 472. I have shown you that Congress has authorized the Secretary for the areas of the Virgin Islands, Guams, and American Samoa, Virgin Islands and the Northern Mariana Islands. It is the Secretary who controls the IRS and who writes the needful rules and regulations for the administration and enforcement of the IRS on the IRC. The Commissioner, which must acquire express leave by Congress to mandate, as mandated by 472, to operate outside the District of Columbia. The Hughes Court claims in error that 267621 is the expressly stated grant of leave required by 472, claiming that the office of the President of the United States is somehow the same office as that occupied by the Secretary or the Commissioner. Now, if you read 7621, it says, establish an alteration. The President shall establish convenient internal revenue districts for the purpose of administrating the internal revenue laws. The President may from time to time alter such districts. And B, the boundaries of the purpose mentioned in subsection A. The President may subdivide any state or the District of Columbia and may unite into one district two or more states. The error of such claim is further exposed by the definitions of the term state and United States that apply to the entire tax code. When used in this title, where not otherwise distinctly expressed or manifestly incompatible with the intent thereof. So the United States, the term United States, when used in a geographical sense, includes only the states and the District of Columbia. Well, right under that, it gives the definition of the term state, which shall be construed to include the District of Columbia where such construction is necessary to carry out the provision of this title. Under this definition, Alaska and Hawaii were removed from the applicability upon, I'm getting tongue twisted here, upon receiving freely associated compact states status, and you go on to read it. Now the term definition, a description of a thing by its properties, an explanation of the meaning of the word or term, the process of stating the exact meaning of a word by means of other words, such a description of the thing defined, including all essential elements, including non-essential elements, as to distinguish it from other things and classes. Even if the several 50 states could be included in the definition of state, one cannot take that is expressly defined as such. The best that can be said is that it is implied, but then that would be the opposite of expressly. See definition above, and contrary to 4 U.S.C. section 72. So I challenged basically the grand jury to challenge the U.S. Attorney and the Secretary's statutory authority to operate within the several 50 states. Proof of jurisdiction is the burden on the U.S. Attorney once it has been challenged by me via the United States law, and no U.S. Attorney has any foundation to assume that the Secretary is acting in his official capacity when there is no evidence to the record to prove that Congress has expressly extended the authority to the Secretary outside the District of Columbia to the several 50 Union states. Again, 472 states that the extension to the authority of all offices of government are to be expressly stated in United States law. The word expressly is defined as opposite of impliedly. Does 7621 expressly extended the authority of the Secretary to the several 50 Union states? Or does it, at best, impliedly do so? Does the U.S. Attorney believe that Title 26, 7621 expressly extends the Secretary's authority to the several 50 Union states? What definition of expressly and state are used to support such notion? How can a reference to the office of the President of the United States be construed as expressly permitting the Secretary to operate? If is 26 U.S.C. 7621 an expressly granted authority when it does not even mention the office of the Secretary at all? And lastly, additionally, what evidence is there to establish the material fact that the President has in fact created internal revenue districts in the several 50 states? Not one U.S. Attorney has ever contended that the President has created said districts in the several 50 Union states. There is evidence that the President created custom districts and that he's authorized the Secretary to create internal revenue districts, but there are no current internal revenue districts which have been created by the President or the Secretary within the several 50 Union states. Now let's look at the footnotes regarding that. Here, you read them. And now, with that being said, the next is the grand jury. When I gave the grand jury a list of questions for the criminal complaint regarding Solar and Henselwood, and that will be coming next. Okay, here is the list of questions for the criminal complaint regarding Solar and Henselwood. Now keep in mind, for those that maybe did not see the previous, I got summons to a grand jury. I asked them to go ahead and investigate these Agent Solar, Special Agent Solar, and Henselwood, which is a U.S. attorney. And in front of the grand jury, as you see here, I told the grand jury about Title IV, Section 72, and explained how I interpret the law. I don't have to be a lawyer to read law. I don't have to be, educated or anything. I read what it says. I define I look for the definitions of the word, and that's my interpretation. Now, if I'm wrong, correct me. If I'm right, then I'm right. So anyhow, if the grand jury foreman, the addressee of the list of questions and criminal complaint, does not receive and open this package which has been specifically addressed to him, and the grand jury, without interference or review by Solar and Henselwood. Now I say that because when I was in front of the grand jury, I asked the grand jury, or the grand jury, a juror asked me, he said, what would you have me ask your adversaries? And I thought, golly, here I went through this whole presentation and he just doesn't get it. And then Like God put it right into my head. He said, ask them if they want the list of questions in writing. So I did. I asked, and there was they all said yeah. But in the meantime, the DOJ got up and said, you send the list to me, or Agent Solar first. And I said, what assurance would the grand jury see the questions? He said, they will if it's applicable. Well, I let that rest, and I looked at the foreman, and you could hear a pin drop. And so this is why I say that, because without interference or review by Solar or Henselwood or others, then said person should be indicted by the grand jury for the United States mail fraud pursuant to 1701 and 1702, because the letter is not addressed to them. So there I state that, I'm making my statement of who I am, and tell them how I appeared, reinstate the facts, and that how I reported certain crimes to the grand jury under the civil authority pursuant to Title 18, Section 4, misprision of a felony, pursuant to the grand jury's request for me to provide a more definitive questions regarding the reporting of the criminal activity for the following named people: Special Agent Solar and Henselwood and others. I have prepared this document for the grand jury review. Now you will see the others in another section. So now I go back and I restate the Title 4, Section 72 argument. And I talk about, excuse me a minute, I talk about, upon the grand jury doing its due diligence into the investigation of the grand jurors, will find the answers from Solar and Henselwood to be non-responsive or evasive in the same manner as you witnessed when I made the jurisdictional challenge to them on January 10th of 2007, because I asked Henselwood right in front of the grand jury. I challenged jurisdiction, and he could not answer. In fact, I explained what goes on here. And I'm just going to skip through it quickly, because you can stop the video and read specifically. So when I go on, I said, the answers given were completely non-responsive to my challenge of the Secretary of the Treasury of the United States authority in the several states, and clearly indicate that Henselwood knows that he and the court do not have jurisdiction on the soil of and under the jurisdiction of the several states, and this was proven certain by his unwillingness to cite the law by which Congress has expressly extended the authority of the Secretary to the several states, and consequently the Secretary's authority over Christopher Rhodes Chapman with regards to any alleged federal income tax, by pretending control and bluffing and manipulate the grand jury after Chapman's challenge to the Secretary's jurisdiction in the several states. Henselwood has violated his oath to uphold the Constitution and the laws of the United States and Chapman's rights as protected thereunder. So immediately after I challenged Henselwood to prove jurisdiction before the grand jury, Henselwood off the record, away from the hearing of the grand jury, he threatened me. And he said, do you know I can have these 2 agents arrest you now and take you to jail? Threatening to jail me, has repeatedly, after repeatedly challenging Henselwood's authority in the several states, and Henselwood refusing to prove his authority as required under the law, as an assault under Chapman, and the abuse of his office as assisting U.S. attorney, and our crimes under the federal and state law. Now, the grand jury is a witness to this. I ought to see, that's a thought. I ought to find out who was in the grand jury and have them come and testify. I request that the grand jury demand that Soler and Henselwood immediately prove their sworn testimony and evidence given to the grand jury that the indictment that they are attempting to obtain from the grand jury is lawfully done and sworn complaint with clean hands. I am prepared to show, with uncontested proof, that the grand jury, on the record, that Soler and Henselwood have conspired to mislead the grand jury by suggesting that they are not required to prove jurisdiction once it has been challenged. They have done this by concealing documents which proves that Chapman is not guilty of willful failure to file, and which clearly exonerates him from the grand jury, or before the grand jury, and by their not doing their known legal duty to prevent and report said crimes after they have noticed the opportunity, Title 18, Section 3, as accessory after the fact, as found in the Exhibit C. I will presume that each member of the grand jury has their own copy of the criminal complaint. Joiner, I gave them on January 10th, which has been filed with over 80 members of Congress. And and all of this that I'm reading here has not been disputed. After 7 years, nobody has said a word. And I'm going to go ahead and let you read there. Now, keep in mind, Dave Maryland's criminal complaint is the basis of my whole argument. This is why I feel it's important that people join the criminal complaint and get on board with this. And so anyhow, tab 5, anything you see exhibits in tab 5 is mostly all in the same criminal complaint and in my joinder. And so here are the questions that I asked the grand jury. The grand jury wanted a more definitive questions, and here it goes. Questions. In Issue B, the memo relates to the Secretary's authority to exercise the authority outside the District of Columbia and not elsewhere, and to enter the several states for the purpose of administrating and enforcing internal revenue laws of the United States in light of 472. All offices of the seat of the government shall be exercised in the District of Columbia and not elsewhere, except as otherwise expressly provided by law. That's a pretty powerful statement, and I believe you have to agree that once you massage this for a while and really get into the depth of it, which is not, it shouldn't take a whole lot of time, you'll understand that every word has its, definite meaning, and it's very supportive to my cause. And so in addition, Chapman demands Soler and Henselwood verify their answers to the following questions to the grand jury. And so here are the answers, the questions again. And there's questions that are relatively simple. We've already discussed them in the handouts. But, go ahead and read it here. You can shut the video off, stop the video at any time if I'm going too fast, which I recommend you do because I think it's important that you understand this. Now here, official powers cannot be extended beyond the terms and necessary implications of the grant. If broader powers be desirable, they must be conferred by Congress. Here I go over expressly, again, the definition, as I've already stated. And here again, just to recap, and I recap this purposely for the grand jury to make sure they see it again, that Congress did write the law expressly extending the Secretary's authority to Virgin Island, Guam, and American Samoa, as you see here. And here. So my questions are, can Solar and Hazelwood or any other produce even one law similar to those cited above by which Congress has expressly extended the authority of the Secretary to the several states which is outside the geographical boundaries of the District of Columbia and not elsewhere? Will Solar immediately provide the grand jury a 2866 certification showing that Solar is not authorized Commonwealth Revenue Agent of the Department of Treasury, or that Solar is authorized by delegation of authority from the Secretary Paulson to administer and enforce internal revenue laws within the several states pursuant to 472, and that Solar and the Commission are acting in behalf and under the authority of the Secretary. The inquiring minds need to know. Then I asked the grand jury, how can I be charged for willful failure to file or any other unsubstantiated charge when I have repeatedly asked numerous of agents and the Secretary for the law by which Congress has expressly extended the authority of the Secretary to the several states? And to this day, after 20 years, I don't get any response. I get no respect. Silence, when they don't respond, can only be equated with fraud. Where there is a legal and moral duty to speak, or where an inquiry is left unanswered, would be intentionally misleading. And that's what they're doing. They're not answering, they're not responding. In fact, when I asked Solar one time, I said, sure it's criminal on your side to not give me the law. He says, it is what it is. But that was in private, and I have no way of proving that. But I can assure you, that's pretty much the way it went down. So anyhow, I asked several questions, as you can see here. Is it not the easiest way to silence Chapman by just showing him the cotton-picking law? It just goes to show that, I wouldn't be making such a stink if they just show me the law, but they don't. Now, I can't sit there as a defendant because they're coming after my property. They're trespassing against my rights. If Solar and Hazelwood and others cannot prove the grand jury even one law which meets the litmus test of 472, how can they justify the investigation of me outside the District of Columbia and not elsewhere and within the several states? If the laws Solar and Henselwood are using to obtain the indictment against Chapman has not been expressly extended by Congress to the several states, does the grand jury have the authority to indict Chapman under the law which does not reach to him in the several states? If the questions are not answered, can the grand jury morally and lawfully bring back an indictment against me? Well, evidently they can't because they haven't. Not that they wouldn't. But is it not the grand jury's duty bound to indict Solar and Henselwood if they are unable to refute or rebut the crimes that they are accused of in this document and the criminal complaint joiner? Does the law forbid Chapman from correcting any documents he perceives to be incorrect, especially when the documents can affect his property and liberty? Can Chapman be willful if there is no known legal duty? To put it another way, can Chapman willfully break the law if he does not attach to him? In other words, can Chapman willfully break a law which does not attach to him within the several states? And, the questions go on. They're good questions. They were very well thought out, and we worked on them for quite a while. If no law exists which satisfies the litmus test of 472 with respect to the authority of the Secretary in the several states, are Solar and Henselwood and others denying Chapman his rights to the protection as mandated by Congress in 472? If so, should Solar and Henselwood be prosecuted for denying Chapman's rights pursuant to 18 U.S.C. 241 and 242, attached hereto and incorporated herein? Is it not true that Solar and Henselwood refused to follow the law as mandated by Congress, that they should be prosecuted for violation of Title 18, 2383? Here I fall back more on David Maryland's criminal complaint because there's other subjects for the grand jury to consider. Like, for instance, in Title 26, Section 83, it gives the power for a taxpayer even to deduct his labor, which is property, for money, which is property. In other words, if I'm working for somebody and my labor is worth $10 an hour or $150 an hour or $150,000 an hour, that's my labor in exchange for property, money. An equal exchange of property can be deducted from gross income. So with that being said, the IRS code allows me to deduct my property in exchange for equal property. Of course, they'll never admit to that, but we cover that, as you can see right here. And there's others. So the information the grand jury needs to know: isn't it true that the court will not accept a grand jury true bill of an indictment against Solar and Henselwood without a true bill having the approval and signature of another U.S. attorney? So it's going to be hard to get a true bill against them, because what attorney is going to go against his teammate? Is it fair that just for Solar and Henselwood to know that their associates will protect them from indictment by refusing to sign the true bill of indictment, while at the same time they deny Chapman's the protection of Congress has given the pursuit of Title IV, Section 72. In other words, is it fair and just for them to protect each other while they commit the crimes against me and then ignore the United States law enacted by Congress, 472? That's why, people, we need to wake up. So with this, I put them on notice, and I end listing the crimes that they are committing. And I'm asking the grand jury to investigate them. Now you can see why I haven't heard from them for over 7 years. But I'm hearing from them now. And that's why this is being exposed. I want every American to see this. In fact, it is my dream that you join me with Wake Up America. And let me tell you why. Because when you join Wake Up America, we're going to be advertising stuff like this on national TV, on the internet. And, you know, one of my biggest things is to raise enough money through Wake Up America and people working the program that we can put billboards along the sign, along the side of the road, and do other massive advertising. Can you imagine somebody going to court for tax evasion or something like this, one of our people, and we have thousands, if not millions, of flyers going out each and every week in the general area informing the people, and not about the court case, but in general about how the IRS is deceiving the people. If we don't do that, we're going to lose. And only through Wake Up America that we can do that. So, I'm asking you to help me, help you to help others. Wake Up America, okay? And in closing on this section, it is my firm promise to the grand jury, as I always state, and my firm promise in C6 here, it says, Chapman has always been making a similar promise. Yeah, I've always done this. I've always promised to pay. Hey, I promised to pay. If you can show me expressly where the law is was extended or given the authority to the secretary in the geographical area of the several states, specifically in Florida. And if you can do that, just Title IV, Section 72. We don't have to think about anything else. I will promptly and within 30 days make arrangements with the IRS to pay all taxes allegedly owed by me for all the tax years in question. I will notify all my friends and associates of said law and recommend to them that they immediately pay their taxes and file their 1040 returns. But the Declaration of Independence says we're all equal. And with that being said, everything must be equal. What's good for you is good for me. What's good for me is good for you. So if Solar and Henselwood cannot produce said law, then I respectfully request that the grand jury immediately begin the indictment proceedings against Solar and Henselwood for the crimes they have committed against me as cited and verified herein. Isn't that a fair deal? Since they've been trying to put me in jail and destroy my life by taking away my liberty, isn't that what justice is all about? The law fairly and equally applied to everyone alike. They don't have immunity. They may think they do, and they may act like they do, and the judge will try to protect them. So, with that being said, here is the verification that was signed on the 17th day of January, and a copy of this went to the grand jury. In addition to, now here is the statutes. that I'm quoting. accessory after the fact, Dave Maryland's criminal complaint, and the definitions of a revenue agent. I mean, a lot of people don't know this. I can assure you the grand jury didn't know it either. But it raises doubt, don't it? That a revenue agent, hold on, a revenue agent, any duly authorized Commonwealth Internal Revenue agent of the Department of the Treasury in Puerto Rico. Same thing with the secretary too, huh? Right there. So wake up, America. Help me wake up, America. And let's turn this country around. I'm telling you, we can do it. And let me go here. Now, the next session after this break is going to be about counterfeit securities. And I'll bring up the title right here. And my notice of affidavit of sham legal proceedings of promoting the counterfeit securities and other violations of federal law. Now here I named everybody and their mother if I thought it would apply. I got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, and now I got more to add. Okay, there's 14. And all these guys, all these people here have not been forgotten. It's been dormant for 7 years, but now they open it up back up because there's no limitations on fraud. And I gave them then, as we'll give them again, I will give them another 20 days to stipulate or rebut all the facts contained therein. But, recognizing if they lay silent, they're put on notice that it is basically a violation of due process of law on their part. Because they're the ones that are claiming that I owe, and they're trying to destroy my liberty. So this goes on, and like I said, this will go on. We'll talk more about this after the break.
In grade school, we learned Congress passes the bill, and the president signs it into law. But instead of writing good laws, Congress passed the buck. And we have left the rulemaking to nameless, faceless bureaucrats that the typical American will never know. It is time to wake up, America. It is time to tell our politicians to write laws the American people can understand and not turn over the rulemaking to the bureaucracy. To learn more about Wake Up America's plan for fixing America, please visit our website.
Okay, here I'm claiming that the December 12th and the January 3rd subpoena to appear before the grand jury is a counterfeit security. And I list the people that are involved, as you can see, and including and not limited to Judge Fawcett. The letter, okay, like I said, it's a notification pursuant to the Bill of Rights and the National Constitution in particular. Then I go on and I'm stating all the facts as I know them. Now, if I'm wrong, I'm making presumptions here, okay? I don't know if the attorneys have an oath of office, but if they don't deny it, then they admit to it. And like Henselwood here, who took a sworn oath to uphold and support and protect the Constitution. Another U.S. attorney, the judge, Patricia Fawcett, was appointed by Ronald Reagan in 1986. O'Connor, the Assistant Attorney General, another agent, all these people, I'm going to assume, and even the clerk of the court, one guy on one of the calls just recently said, well, what about the clerk of the court? You know, he has a notice of federal tax lien. Well, he's involved in you got to put him on notice that there's an involvement and then now go after him. Now, I haven't been diligent about going after these people after I sent them in because I was getting ready to if they wanted to keep moving forward, but they didn't. But in the last week, now they have. So now I'm compelled to move forward myself. This is why you're getting to see all of this now. And here, you know, again, all the agents and so forth. Here you'll see 250.11 define the definition of internal revenue agent. It is now 36.11, so they changed it. And then I'm stating I'm domiciled in one of the several 50 states, republic. And delegation, I go through the definition. Delegation of authority means a complete list of the Treasury delegation orders. And I list them as how they applied. And then here I'm stating that Congress can tax citizens within Washington, D.C. and the territories of which it has exclusive legislative jurisdiction, since Congress is not limited by the Constitution with regard to Washington, D.C. and the territories, or other unincorporated areas over which it has exclusive legislative power or legislative jurisdiction. However, to tax beyond the borders of Washington, D.C. and the territories within the several 50 states, Congress must have a specific power granted by the Constitution giving it legislative jurisdiction over said areas. For this reason, United States Law 15 U.S.C. Section 17 clearly states that the labor of a human being is not a commodity nor an article of commerce. So based on said statute, Congress does not have the power to tax labor under the commerce power, since labor is not a commodity or an article of commerce. Therefore, affianced labor cannot be taxed as a commodity or an article of commerce under the commercial power of Congress. Then go ahead and read some of this. Here again in this, I'm going over 472. I'm really hitting home because nobody responds. No IRS agent may file a lien, nor has the authorization. For those who have liens and levies, I put this in my criminal complaint. And again, once you send it to them, they're hereby noticed they're committing a crime. And if they don't correct it, we can now go after them. Here I'm showing that I met with an agent years ago in 1999, and and she ignored the request for delegation of authority. They all do. They always do, because they don't know what you're talking about. Because if they did know what you were talking about, you wouldn't be having the problem that you're having, would you? And then here, I asked Agent Solar when we first met for his delegation of authority. And he admitted that I do not have one of those with me at this point in time. Well, he didn't have it with him then, and he doesn't have it now, and he even admitted in court on the witness stand under oath he doesn't have a delegation of authority. In fact, this guy, for a special agent, didn't even know what a direct tax is. I mean, which kind of blew me away. Here's a revenue agent doesn't know what a direct tax is. I find that odd, don't you? So here, as we move on, here is where it says affiant subject and liable for a tax in doing. Yeah, on January 4th of 2007, David Solar and Iran, how you say his name, Cyril, came to affiant's location to serve upon him, the affiant, a sham document and counterfeit security titled amended subpoena. When asked if he could state what federally regulated activity the affiant was involved in that makes the affiant subject and liable for a tax due and owing the United States Treasury, Solar responded, I can't do that. That's the way it is. See? He said he can't do it. There he admits it again. I can't do that because there isn't any. That's why he can't do it. See? These guys here are falsely accusing, and they know it. So this is why I charge them with all these charges, and the grand jury has got to support it. So with this here, I have the ammunition now to go in front of, to start an action, especially now that they're coming after me. Because if they had left me alone, I probably wouldn't be doing this. But now we need to do it. And why? And I'm just going to finish up here, and then I'll get into a little discussion. And the U.S. Attorney will not certify the Internal Revenue Service as an agency of the United States because they can't. Okay, so failure to provide the above certified and verified documentations within 10 days. Now, I've given them 7 years. You think that's long enough time? And notice them that if they remain silent, it's their tacit agreement to their commercial dishonor and their tacit agreement for a summary judgment entered into the record on the court of my choosing against Randall Gold and the rest of them and all agents for the fact of causing assault and continual commercial injuries over a period in excess of 10 years to Christopher Chapman in the sum of $500,000. So that's what I got to go in for. Are you in, or are you in with me, or are you out? Okay. Now, obviously, I got to start doing something. And we'll end here for a moment, and I'll be back.
But there was that ant that stood up to me.
Yeah, but we can forget about him.
Yeah, it was just one ant.
One
ant.
Yeah, you're right. It's just one ant.
Yeah, boss, they're puny.
Puny? Say, let's pretend this brain is a puny little ant. Did that hurt?
No.
Well, how about this one?
Are you kidding?
Well, how about this?
You let one ant stand up to us, then they all might stand up.
Those puny little ants outnumber us 100 to 1. And if they ever figure that out, there goes our way of life.
It's not about food. It's about keeping those ants in line.